Welcome everyone. I'm joined today by the Honourable Michael Kirby. Justice Kirby is a distinguished jurist, author and academic who served as Justice of the High Court of Australia from 1996 to 2009. He has served on many national and international bodies, including as member of the World Health Organization's Global Commission on AIDS, as President of the International Commission of Jurists, as UN Special Representative for Human Rights in Cambodia, as a member of the High Commissioner for Human Rights Judicial Reference Group, and as a member of the UNAIDS Reference Group on HIV and Human Rights. Today, Justice Kirby is going to address us on the subject of the Australian Constitution and queer rights. Welcome, Justice Kirby.
Thank you very much, Alana, and I pay my respects to you and to other teachers of law at UTS and to the students who are taking part in these conversations. When I was about 10 or 11, I realized that I was homosexual, gay, queer. And when that happened, I felt as if I was outside the law, because I didn't know much about the law at that age, but I knew this was not a good discovery. In 1955, a book was published, which was the last year of my schooling, and just before I went to the University of Sydney, which was the only law school in that time. And the book was Peter Wildblood's Against the Law. This is the book. It has been republished, and it was the first book by somebody who had got caught up in a major scandal involving a peer of the realm and other distinguished people for homosexual activity. And the other two were prosecuted, and they gave evidence for the Crown. That evidence assisted in the conviction of Peter Wildblood. He refused to give evidence to the Crown, and he refused to feel ashamed of himself. This was an eye-opener for me, because at that time, every queer person was expected to feel thoroughly ashamed of themselves. And that led to a thought buzzing around in my mind when I first got to law school in 1959, 4 years later. What was the reason behind the laws that stigmatized and punished gay people, whether or not what they were involved in had their consent, whether it was in private, and whether the other persons were adult. And that was the thought that was in my mind when I undertook my first year course at the University of Sydney, which included a course in criminal law. It was given by Mr. Vernon Triet, QC, who was a politician and an experienced lawyer. And he took the class, which was then sitting in the Phillip Street Theatre, which by night had theatricals, and by day had law students, not a dissimilar group. At night, Barry Humphries first strode the lights at the Phillip Street Theatre, and at a certain point in his lectures, he got to section 79 and section 80, the so-called unnatural offences concerning homosexuals and their punishment. 14 years was the punishment which was established for homosexuals. And I remember at the time that happened, I felt that I was blushing. I was very frightened. Would anybody know that this was about me? And I, unlike Peter Wildblood, felt thoroughly and completely ashamed of myself. I found that one of the professors that I most admired, Professor Julius Stone, had written an article on the issue of propensity evidence against gay people, in which gay people were described as perverts, and in which the law was interpreted and explained in a way that would be unfavorable to the a gay person if charged. And this was the world in which I grew up as a young person and as a young lawyer. And it was a world that was extremely hostile to gay people. And it's important that people of my age should try to explain to those who come later that as with women, as with Aboriginal people, as with people who were not Caucasian, whites, LGBTIQ people were stigmatized and punished and hated, and even by their parents and even by their siblings, they were outside the law. And this was the world in which I was aiming to practice as a lawyer. Subsequently, I was appointed to the Law Reform Commission, the ALRC, and in the course of that work, I was sent to Paris to chair a committee of the OECD on privacy protection. And that committee developed principles for the protection of privacy, substantially in the context of computer information, which was then rapidly expanding, but also more generally in society as a whole. The principles of the OECD were ultimately adopted by the Council of the OECD, and those principles were then introduced as part of the Privacy Act of the Commonwealth, and they were enacted by our Parliament. Privacy, you see, was a very important tool that became to be used by constitutional courts to strike down legislation that provided the old British common law and statutory offence of unnatural crimes. And so in that way, I began to think about whether the principles of the OECD might at some stage be useful. And at that stage also, I met my partner, Johan. As it happens, the day I'm giving my talk that will be used by UTS is the 53rd anniversary of our meeting and the 50th of the third anniversary of our marriage, which became possible as a result of one of the cases that I'm going to briefly talk about. In 1994, the meeting with Johan was in 1969. In 1994, most of the states of Australia and territories had got rid of their unnatural offences, and they did that by legislative means. One state alone held out. That was the Apple Isle. Tasmania would not amend its laws. Every attempt was made to persuade them, to give them information, and ultimately the federal parliament enacted a law called the Human Rights Sexual Conduct Act. And that act provided that no person would be prosecuted for a crime and the so-called unnatural offences if they were over 18 and if what had happened was done with consent and in private. And so there was a clash, a pretty classical clash between a federal act and a state law. And Section 4 of the Federal Act provided that any state law that was incompatible with this new Federal Act would be invalid under the Constitution. At that stage, Rodney Croom, who was a gay activist in Tasmania, and his partner Nick Toonan got in touch with me and they asked me, would I be prepared to help them to get to the United Nations, where the case of Toonan against Australia was being heard. That case became the footing of the implementation of the principles, the privacy principles, which had been adopted by the OECD committee, which I had chaired. So these were my two connections with this later development, personal connections. The third personal connection, of course, was also the fact that I knew that I was one of those who was targeted by these laws. In any case, I told Rodney Croome that I thought they were wasting their time going to the Human Rights Committee in Geneva, because I was pretty sure that because they were not being actually prosecuted, but were just being stigmatized, they would not have their case accepted by the Human Rights Committee and stigmatized in Australia because of the Tasmanian law. I said, don't do it. Don't go to the United Nations. There's no way they're going to take up your case. But I will give you some money to assist you. And I offered a paltry amount, but it was something. And they immediately, that very afternoon, took their case to Geneva, to the Human Rights Committee of the United Nations. It did intervene. It did uphold their complaint against Australia, and that holding became the basis of the Human Rights Sexual Conduct Act of the Commonwealth. And that led to an attempt by the federal parliament in enacting that provision to override the Tasmanian provision, and hence the Australian Constitution was introduced into the drama. And that constitution, as you know, provides that in the event that a federal act is enacted that covers the same field as a state act, it will bump out the state act. This is the federal supremacy provision of Section 109 of the Constitution. And so then a case was brought because Tasmania still wouldn't buckle. There are stubborn people down there in Tasmania, and they wouldn't introduce a law, and they decided to challenge the Federal Act. They were doing so in relation to the treaty power which had been used by the Federal Parliament to enact the provision, and that treaty power was used on the basis of the OECD principles, which I had assisted to their birth a decade earlier. Those principles therefore came before the High Court in the challenge which was brought in that court against the validity of the Federal Act. The state of Tasmania brought proceedings against validity, and the state of Tasmania was challenged by Rodney Croome, and he said that the law was not that the law was valid, and it applied to him. Tasmania, ever resilient, resisted the case that Rodney Croome had brought to strike down the law, which was Section 122 of the Tasmanian Criminal Code. But the Attorney General of Tasmania objected to that contention on the basis, which had been the basis that concerned me about their case, namely that they were not being prosecuted. Therefore, there wasn't a live controversy. There wasn't a matter within Chapter 3 of the Constitution, and therefore that the High Court had no jurisdiction to strike down the Tasmanian law. That all goes to prove how important it is in challenges on basic principles to show courage and to show determination and to get good lawyering and to take up matters which others say are hopeless because there may just be a point. And the result of the case of Croom against Tasmania, which was in 1997-98 and is reported in 191 CLR, in that case, the High Court rejected the contention by the Attorney General of Tasmania. It rejected the contention that Mr. Croom did not have standing to bring his challenge, and it must have been that Tasmania drew an inference from the objections of Rodney Croom that it wasn't looking good for Tasmania in the challenge, that the matter was left with the Tasmanian statute standing, but being challenged by Rodney Croom and his partner Nick Toonan. But lo and behold, when that case was challenged, I had been appointed to the High Court of Australia. That case was 1997-98. My conversation with Nick Toonan and Rodney Croom was back in 1994. At that stage, I never considered that I would be appointed to the High Court, and I gave my free advice a bit of money and told them it was hopeless and they shouldn't go ahead. But they did go ahead, and they got a very strong decision of the UN Human Rights Committee. And when the matter came to the High Court, it rejected the challenge, and as I've said, that then led Tasmania to reconsider its position, and the government of Tasmania announced that it was going to take proceedings in the Parliament of Tasmania to repeal Section 122 of its criminal code with its provisions in relation to so-called unnatural offences. Up to this stage, the lesson of all this was that I had given very poor legal advice to Rodney Croom and Nick Toonan, and the case was pursued by them. They succeeded before the Human Rights Committee. That led to the federal statute, the Sexual Conduct Act of 1994, and the challenge was rejected. The challenge to the standing of Mr. Croom was rejected by a unanimous court, but I was missing because by reason of having got involved in it before my appointment to the court, and by reason of my giving money to them, there was no way that I could participate in the case. I wouldn't otherwise have disqualified myself, but I did disqualify myself. The media pounced like vultures. They wanted to know why Justice Kirby was not sitting in the case, because I had spoken in Tasmania in favour of repeal of the provision before I was appointed to the High Court. But sit, I did not. And that was my first encounter in the High Court with a case involving sexuality and the Australian Constitution. There aren't many such cases. There were quite a few cases in the court concerning whether a gay person who was not being prosecuted would have a well-founded fear of persecution if returned as a refugee applicant to his country. And that was brought, that particular case was brought by two gay activists in Bangladesh. But constitutional cases were hard to find, because the hook on which a constitutional case has to be hung is a hook that is based in the text or interpretation and purpose of the Constitution. And of course, the Australian Constitution doesn't have any such specific text. In more recent years, a number of cases have been brought in other constitutional courts that have resulted in the striking down of the so-called unnatural offences. Such a decision was brought in Lawrence against Texas in the Supreme Court of the United States, where the privacy principle was invoked by the justices in the majority, and that was how that court dealt with it and held that the unnatural offences were incompatible with the constitutional protection of privacy in the US Constitution. Likewise, in India, the Indian Supreme Court, in the case called Johar against the Union of India, it was struck down on principles of equality, of citizenship, and of privacy, which have been found in the Supreme Court of India. And more recently, a case in Botswana, as recently as late last year, the Court of Appeal of Botswana upheld the decision of the judge of trial at first instance, striking down the Botswana criminal code insofar as it punished gay people for their sexuality or conduct. Interestingly, that decision was written by a distinguished justice of the Court of Appeal of Botswana, the highest court in that country, whose name was Kirby. In fact, he was the president of the Constitutional Court, and he therefore appears in the record as Kirby P. Now, I tell this to students so that when they see the decision in Botswana, they won't think that I had slipped into a plane and rushed over to Botswana, clutching my horsehair wig and all the other accoutrements of my days as president of the Court of Appeal at New South Wales to re-emerge as Kirby P of Botswana. I didn't do that. This was another Kirby P, and he wrote a very strong and very impressive decision, I think, striking the law down. But he had hooks on which he could do it. They were the provisions of the Constitution of Botswana dealing with liberty, with privacy, with dignity of citizenship, and with discrimination. And so once you've got a hook in the Constitution that is specific and clear and applies to the case, you can mount an argument. If you don't have such a hook, it's very difficult to mount the argument. But in the case of the Commonwealth against the ACT in 250 Commonwealth law reports, such a case arose. I didn't have to disqualify myself in that case because that was decided a few years after I had concluded my service on the High Court of Australia. And that was a case where the legislature of the ACT decided to enact its own Marriage Act on the basis that, as the Commonwealth was asserting, the Federal Act did not apply to a same-sex marriage. And so the question came to the High Court as to what marriage meant. And that led to argument of whether marriage in section 51(21) of the Australian Constitution was only a marriage at common law, which was a man and a woman, and didn't extend to a same-sex relationship. Ultimately, the High Court of Australia held that that was not a view that should be imposed on the federal power. The federal power was wide enough to support a same-sex marriage in federal law, although that had not been enacted. And that, therefore, was the position that was reached in Commonwealth and the ACT. The High Court unanimously Chief Justice French, Justices Hayne, Crennan, Kiefel, Bell and Keane all decided that the power in the section of the Constitution was not confined to same-sex, to opposite-sex couples, and did extend, if the federal parliament chose to use it, to same-sex couples, and that was, as you know, ultimately done. And in fact, this is the 53rd anniversary, as I've said, of my marriage, and it's therefore an appropriate day in which to celebrate the decision of the Commonwealth and the ACT. At the time, I was concerned that the High Court didn't move in and say it is implicit in the marriage provision that it must not discriminate, because that is a way it could have been interpreted. But instead, the High Court said this is up to Parliament, and Parliament ultimately ordered a ballot, and that ultimately led to the enactment of the changes to the Marriage Act, and that ultimately led to the availability of same-sex marriage. But it's small pickings, and that is therefore the end of this talk, because I see that we've lost the Zoom.
Yeah, so sorry, just towards the end there, your video seems to have turned off again. I'm not quite sure why, but thank you so much.
You'll probably be able to cut and paste it and use part of it.
I think we'll be able to use the whole thing, because it was an absolutely wonderful to hear the history of the law as it applies in this context, enlivened with your personal recollections. And, you know, I was absolutely enthralled. I'm sure the students will be too. So just wanting to thank you, and particularly for joining us on the day of your anniversary, and wishing you, very happy anniversary with your husband. And
thank you.
I hope
we call ourselves partners. We're sufficiently old-fashioned to find a husband, because our relationship is not that of husband and wife. Our relationship is that of partners, and many straight people have problems with some aspects of marriage, but according to the Hyde versus Hyde definition. But anyway, there it is. We were duly married under the law of the Commonwealth, and that was a long journey which began with Peter Wildblood, who was a very brave man, and he refused to be ashamed of himself. And that is a lesson for all people challenging human rights. You've got to be brave, you've got to be courageous, you've got to be determined, and you mustn't get bad legal advice early in the step, or you might never do anything.
Yes, that was very amusing to hear that. So again, thank you so much. Wishing you a very happy anniversary with your partner, and I hope you have a wonderful celebration this evening.
Thank you very much. Thank you, Alana. Good
Thank
luck
you so much
to
for your
you,
time.
and I'll be in touch, and I hope it's